Since 2020, you never took your child to the hospital, emergency rooms, or to see a pediatrician?
Personally, I haven't. I do not know what Norma has done.
All right. Did you ever ask her, hey, she's not eating right, something's going wrong? Have you taken her to the doctor? It appears that this is something that was happening over time. Am I right? The fact that she's not gaining weight, she's not eating. What was her highest weight? Because this is saying that she was 27 pounds at 10. So before she started dropping all of the weight, what was her weight as a 10-year-old? The court is going to call 2023 CR 4168, State of Texas versus James Michael Kennedy. And defense, if you all could move to that end. Could I have parties announced for the record for the state?
Zach Dunn for the state, Your Honor.
Defense?
Anton Hayek. What did you ask me to do, Jed?
No, I'm asking your name.
Anton Hayek. But they
Yeah.
told me to move one way.
No.
Okay.
Okay. So Mr. Hayek, for the record, is representing Mr. Kennedy. And are you James Michael Kennedy?
Yes, Your Honor.
All right, you entered a plea to the offense of assault, intentionally knowing serious bodily injury of a child by omission. You entered a plea to a cap of 35 years in the prison. The state is opposing your application. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
I've had a chance to review it. I've reviewed it with my client and given him an opportunity to read it at his own pace.
Okay. All right, any objections to the PSI report, state?
No, Your Honor.
Defense, any
No, Your-
objections?
No, you're not.
All right, state, any witnesses?
No witnesses, Your Honor.
Defense, any witnesses?
Mr. Kennedy, please.
All right, Mr. Kennedy, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, Your Honor.
All right, you can lower your hand, state your name for the record, please.
My name is James Michael Kennedy.
All right, counsel?
Mr. Kennedy, would you say this event with your daughter finding it out about cerebral palsy and having her removed from your presence because of lack of proper nutrition was a real eye opener to you?
It was.
Okay.
Yes, sir.
I'm sorry, could everyone please whisper? And counsel, if you could speak up for me, please.
And during the first 10 years of Michelle's life, did you think there was anything unusual about her not being able to eat solid foods? Well, other than that, she probably should have.
Given her state with cerebral palsy, I didn't know.
And the primary caretaker, Michelle, was Norma, is that correct?
Yes, sir.
And you live with Norma, you're not married to her.
Yes, sir.
Did Norma ever have any complaints to you about something she wasn't allowed to do for Michelle?
No, sir.
And you've read the report and you're happy with Miss, I can't do her name, Sitsu, the foster mother?
Yes, sir.
Okay, and I read you the expert. Do you agree with what she wrote?
Yes, sir, I do.
Okay. And do you want the best for your daughter?
I do, yes, sir.
And you've had a hearing in CPS court on Valentine's Day where you gave an affidavit of relinquishment of your parental rights?
Yes, sir, I did.
Okay. So do you feel sorry for what you either did or failed to do for your daughter?
At the time, I wasn't aware, but yes, I do.
Okay. So you realize the judge is probably going to send you to prison.
Yes, I do.
Are you asking for something maybe in the 20-year range as opposed to 35?
I am asking for leniency.
Okay. No further questions. That's a prosecutor may want to ask you something.
All right, in just one moment, my email went down. I did have the PSI report up, but the PSI report has disappeared on my system. All right. Questions?
Yes, sir. Just a few, if I may. Mr. Kennedy, my name is Zach Dunn. I'm one of the prosecutors in the Family Violence Division. I should have a few questions for you, and some of it goes to your statements in the PSI, which is the report that the judge is looking at right now. You basically mentioned on kind of the last page of it that you really kind of didn't know or were unsure of the fact. You said you had ignorance of your daughter's condition. She was diagnosed with cerebral palsy at birth, though, correct?
I do not know.
With respect to her abilities, things she was able to do, did you notice any kind of comparison between her and other 10-year-olds?
Actually, comparison between her and when I was going through high school, I noticed that there was children that were similar.
And are you aware of how much she weighed as a 10-year-old when the police came to the residence for the first time?
I believe she was at 27 pounds, but I can't remember.
27 pounds as a 10-year-old. Does that seem normal to you or abnormal to you?
I do not know. I mean, when I look at, when I remember how there were others that were her age, more or less, even, and when I was going through high school, I saw that they were about her size.
You're saying when you went through high school personally,
When I went through high school,
you knew of 10-year-olds that were around 20 pounds in weight, or
we went to the kitchen cafeteria, and I saw others that were rolled around in wheelchairs that were about the same size.
and what did you make of the fact that Michelle, again, a 10-year-old, was unable to speak and barely even move when the police first interacted with her coming on scene? Is that normal behavior, you think, for a 10-year-old?
I think given that she had cerebral palsy, that it was normal.
And with respect to her diet, do you think it's appropriate to feed someone Oreos, milk, and Kool-Aid to sustain their life as a 10-year-old with cerebral palsy?
Michelle could not eat solid, so she couldn't even eat Oreos.
Okay, but at the time, does it surprise you, or is it surprising to hear now that y'all's statements at the time on scene was that, again, you fed her Kool-Aid, milk, and Oreos?
At that time, given that Norma was taken to her to the doctors, and that the doctors were aware of what was going on, I thought everything was okay. Given that now I know that it's not okay, because that could have all been avoided with the surgery of a G tube, gastrostomy tube.
You said you know about that now.
I do.
So if police had never come and CPS was never involved, what do you think the future of Michelle's life would look like? Again, at the time, she weighed 27 pounds as a 10-year-old. That was a few years ago.
Well, she did lose a lot of weight due to her being sick. It wasn't due to lack of us providing nutrition. It was due to her being sick that she lost weight.
No further questions, Ron.
All right,
That's
any
it, John.
follow-up?
A follow-up,
All right, may I
Right.
ask a question?
please.
All right, why was she never placed back in school?
When she was originally taken out of school due to the coronavirus.
All right, and then after
when
that?
we attempted to take her back to school, she could never keep the mask on. She would keep constantly pulling it off. And then they told her to no longer go back to school.
I'm sorry, what?
They told her not to go back to school until she could take care of that.
Okay. And I'm sorry, I'm trying to find the trial court certification form. Just 1 second. I'll have it. All right, so you're saying that they didn't allow her to come back to school because she continued to pull off her mask.
Yes, ma'am.
And the offense date on this is 2023. So help me, in 2023, were students still required to wear a mask?
I do not know, Your Honor.
All right, so you didn't take her back to school in the year of 2023.
No, Your Honor.
And I read the PSI report, and it said that you had personal insurance.
I do. Oh, I did.
All right, so at that time you had personal insurance, correct?
Yes, Your Honor.
How often had she seen a doctor?
I believe the last time she saw the doctor was in 2020. And I believe it was on a either annual or duannual checkup. I left that all to Norma to take care of.
All right, So the last time she saw a doctor was in 2020.
Yes, I believe so.
So did your wife, Norma, have the insurance card to take her to a doctor?
No, Your Honor.
All right, so
No,
you
it's
had
not
the,
his wife, they just live together.
all right, so the person you lived with, were you in a romantic relationship with them?
Yes, Your Honor.
All right. And were you all living together as boyfriend and girlfriend or husband and wife?
Yes, Your Honor.
All right, and so you left her in charge of taking care of your child?
Yes, Your Honor.
And is she the biological mother of that child?
Yes, Your Honor.
All right, so you didn't give her your insurance card to take her to the doctor for emergencies?
I never was issued one. Everything was done electronic.
All right, so since 2020, you never took your child to the hospital, emergency rooms, or to see a pediatrician?
Personally, I haven't. I do not know what Norma has done.
All right, did you ever ask her, hey, she's not eating right, something's going wrong? Have you taken her to the doctor?
This will actually all happen recent, like because she got sick because of everything that happened. We took her to the hospital to Christus Santa Rosa at first. And
When was that? Was that in 2023?
yes, Your Honor.
All right, I'm talking about before 2023. Unless, and if I'm wrong, correct me. And I won't take offense to you correcting me. It appears that this is something that was happening over time. Am I right? The fact that she's not gaining weight, she's not eating?
No, Your Honor. The way we were giving her nutrition over the time period from her birth until the time that she got sick was the same constant method.
Okay.
And then all of a sudden she gets sick and she lost the weight.
So what was her highest weight? Because this is saying that she was 27 pounds at 10. So before she started dropping all of the weight, what was her weight as a 10-year-old?
I believe it was either at 40 or 45 pounds.
So 45 pounds, and then all of a sudden she's at 27 pounds.
Yes, Your Honor.
So you didn't think to take her to the doctor when she dropped down to 30 pounds?
I would be at work, so when I would come home, I'd always want to try to sleep or relax just before sleeping.
All right, and how far did you go in school?
For school, I graduated from St. Philip's College.
Okay,
I got my certificates for aircraft and power plant.
all right, thank you. Any other questions, defense?
No, Your Honor.
State, any other questions?
No, Your Honor.
All right, the court will hear argument. The state is opposed to the application. State?
Your Honor, this is an individual that essentially the state doesn't believe has taken responsibility. The litany of I don't knows and I'm not sure. This doesn't replace the fact that you're talking about a 10-year-old who had, as the medical facility diagnosed her with, quote, extreme prolonged malnourishment. 10-year-olds are somewhere in the range of above 70 pounds. This is a 27-pound individual who, through the defendant's own words, was fed Oreos, Kool-Aid, and milk. As if being a child wasn't a vulnerable enough position to be in the world, to be diagnosed with cerebral palsy at birth and have parents that don't take you because their insurance quote has expired and knew about first they knew about the diagnosis, but then they didn't know about the diagnosis, as they later said. The state would, of course, respectfully request that the court take all these factors into consideration, given how this person completely disregarded the health of a young girl for many years on end, Your Honor.
All right, defense?
This case has a certain horribleness factor, especially to me as a parent. I can't imagine not feeding your child, and this is my second sentencing on this crime in a week.
Yes.
So I didn't know that many people weren't feeding their child. In representing my client, he's basically been clueless. I've had a very difficult time getting to him to understand what he did or did not do and what he should have done or should not have done. That doesn't condone what happened to his daughter. One thing I don't understand is how she went to healthcare providers and no one noticed anything, especially on the day in which she was taken to a healthcare provider a second time, and that's when she was taken into police custody, CPS custody. Okay, and you have terminated your parental rights, is that correct, sir?
Yes.
That's it, Your Honor.
All right, one final question. So what were you eating?
I would eat out a lot.
Okay. And did your weight ever drop at normally low?
No, Your Honor.
And how much did you weigh?
Before I was at 277.
All right, so if your weight went from 277 down to 100 pounds or 90 pounds, would you go to the doctor?
I would find out what's going on, yes.
Okay. All right, the court is going to deny your application. The court will find you guilty. I understand that there may have been other issues at play here as far as maybe the mother was in charge of taking care of your daughter and during the day-to-day. So I am taking that into consideration. I'm going to sentence you to 34 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with the complainant. There's to be no unsupervised contact with minors. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Which time? Yes, Judge.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Kennedy, I understand that you're probably hurt by what happened to your daughter. I do understand that. But children are 100% dependent upon adults. They're dependent on them to feed them. They're dependent on them to clothe them and for them to be educated. And you can't say your responsibility, I'm just outside working, somebody else is taking care of my daughter and I'm not noticing anything. You understand?
I understand, Your Honor, and I wish I did really know what was going on, like when CPS came by, my caseworker, she gave me all this paperwork
Mhm.
and I was reviewing it. It was at that moment that I understood
Okay.
the level of care that she demanded and she needed.
All right. Well, good luck to you. Okay.
Yes, Your Honor.
All right. Thank you so much.
Thank you.
Thank you. Yes, thank you. Veronica Alvarez. Are you all ready to proceed? All right, court is calling 2022 CR 9445. State of Texas versus Veronica Alvarez. Excuse me, Mr. Bonk, if you could move him down there. Could I have parties announced for the record for the state and defense?
Joseph Stateson standing in for Joanne De Hoyos.
And are you Veronica Alvarez?
Yes, Your Honor.
Do you have any objection to this attorney standing in for Joanne De Hoyos?
No.
All right, you're going to need to keep your voice up. I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Veronica Alvarez who was placed on deferred adjudication for the offense of possession of a controlled substance, penalty group 1, less than 1 gram on March 30th, 2023 for a period of 3 years? Is that you?
Yes, Your Honor.
State.
Yes, Your Honor. Violating condition number 5, Ender County, Texas, the defendant, Veronica Alvarez, did then and there fail to report to the supervision officer as directed for the months of June 2023, July 2023, August 2023, violation of condition number 5.
How do you plead to that? True or not true?
True.
State.
Yes, Your Honor, it's an agreement between.
Do you waive the remaining allegations?
Yes, we do waive the remaining violation.
Any objections? Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, Your Honor.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There is proposed, Your Honor, to adjudicate guilt, revoke the individual.
Quiet, we are on the record.
revoke her off of her probation pursuant to 1244, assess 112 days in the Bear County Jail.
All right, you may take a seat and continue to confer. Is that the agreement?
Yes, Your Honor.
Are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, the court will find violation of condition number 5 true. Probation, are you in agreement with revocation for Miss Veronica Alvarez? The court will find you guilty, sentence you to 112 days in the Bear County Jail under 1244. Give you credit for any time served. I'm going to show you what's entitled Trial Court Certification. A defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement. And because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. If you have a drug or alcohol problem, which it appears that you do, you are always able to have free services here in Bear County to help you with that. If you feel like you can't find a place to help you with that, guess what? You can always come back here even though you're not on probation, and I will give you resources so you can get help with that. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Judge.
You're welcome. Camillus Galvan. No, he can go back. Mr. Reed, good luck to you.
Thank you.
All right, if you need anything, let the court know, okay?
Yes, ma'am. I appreciate everything.
All right, take advantage of it, okay?
Ma'am, I'll do.
All right. All right, Camillus Galvan. The plea deadline date was on February 8th, but then we were recalling it for today. Where are we?
Your Honor, if I may, I believe today's setting was regarding an motion, our defense's motion to appoint a reconstruction expert. Defense is requesting $2,500 for an accident reconstruction expert.
All right, did you all follow motion?
Yes, ma'am.
Let me see. To the clerk, can you pull that motion for me? Wait a minute, I do have it. I'm sorry, thank you. It's hidden under other paperwork.
We have had a setting in between.
Oh, actually, that was appointed, that expert was appointed on January 22nd
Oh,
for $3,000, and it was not to exceed the $3,000. The only issue was I could not write in someone's name because you all didn't have someone's name. But it is in here, motion for appointment of an expert.
yes, Your Honor. Palacios reconstruction expert. Palacios reconstruction is who we use.
Yes, so I approved the motion for appointment of an expert for $3,000.
Thank you, Your Honor. I apologize.
No problem. On this case, can I have a 1 month reset, please? Well, no, I'm sorry, make it 45 days. At that time, you need to have spoken to your expert, and then it's going to be a quick turnaround date for a plea deadline date, and then perhaps jury trial date.
Yes, ma'am. We'll be ready. If I may, Palacios Accident Reconstruction LLC is who we use,
Okay,
please.
all right, thank you. All right, we're going to come back on April 4th. Once you sign the reset form, you are excused.
Thank you, Your Honor, very much.
You're welcome.
Appreciate it.
Thank you.
Thank you, Anna.
You're welcome. All right, who is here on Madison Delosier?
Good morning.
Good morning. Delosier, come forward.
It's an op. You've been on probation for a while.
All right, this is a request to travel. Is there any objection to the travel?
Just now conferring with defense on this, I think we would judge due the nature of the offense.
All right, do you have a copy of your motion?
No. Yes. I do. Miss.
Thank you.
Lean on to the rescue.
All right, she wants to travel to Vegas for her honeymoon. Congratulations on the wedding.
I'm conferring with probation on this, judge, and I think if we could do either an alcohol patch or a drug or alcohol test when she gets back, I think that would take care of our concern.
All right, I don't know if they're able to, does the patch test for alcohol? I don't think it does. I could be very wrong on that. No, so the patch doesn't test for alcohol. So April 5th, what day of the week is that?
It's a Monday through Friday, according to my client.
All right, when are you coming back on Friday?
It would be an early flight, both of them. So we haven't booked it yet. We've looked into it.
All right, so you need to be back here on Friday to take a alcohol test. And other than that, does everybody agree with her to travel for her honeymoon?
Yes, sir.
All right.
Secondary item. But
Judge.
you probably, I'm not sure if we put it in, I'm sorry, I'll wait for you.
No.
I guess it'd be more fair to say that we would leave it in your hands, judge, rather than that we agree.
Okay,
Hank's gonna stop talking now.
all right, so secondary issue.
I don't know if we detailed in the motion, she has had a portable device this whole time. She's been doing very well this whole time. She is now eligible to receive her actual TDL back. The only way she can get it back, though, is with the ignition interlock requirement. So I'm asking the court to allow her to switch from her portable to an ignition interlock requirement, allowing her to get her TDL back, Judge.
All right, state,
Yes, ma'am.
do you have any objections to her switching or probation switching from portable to ignition interlock?
I would like some more time, judge. I don't think defense counsel has spoken to probation about this or us, so
All right,
like some time to talk about this one.
counsel, when she comes back, you'll have to file a motion for that.
So, okay,
We'll hear it at that time.
thank you, Judge.
All right, and you're to do a UA upon your return on April 5th. Do you understand?
Yes, sir.
All right. All right, is there anything else?
No, ma'am.
All right, thank you.
Judge.
All right, I'll take care of it. Hank Finney.
Ma'am, yeah, present.
Your client was late, although I saw him in the elevator.
Your Honor, I think it explained to him, he came, but the door was locked. He had to go to the restroom really badly. He goes to the restroom and he comes back and you call the doctor. So
All right, he can't be late. So that's the end of that. So on February 22nd, today is the plea deadline date. Is he accepting the offer or not?
No, he's not accepting.
All right, state,
Yes, Your Honor.
how long do you think this trial will last?
Finney, Your Honor,
Yes.
2 days
All right.
maximum.
All right, so let me see.
I'm thinking probably 3 days, Judge, not 4, to be honest with you.
All right. Family violence, are you all up the week of March 11th?
I believe that's correct, Judge.
All right, could you recall this for March 11th? All right, jury trial, March 11th. Have a great day. And you always dress appropriately for court. I appreciate that. So they'll give you a reset form.
Thank you, Judge.
You're welcome. All right, and can you call an interpreter up? Yolanda Kaufman?
Your Honor. On this case, we
Well-
were just,
Just 1 second. I was just saying, do you need an interpreter or no?
not really, because we're just gonna ask for a reset. She hasn't been contacted by
Well,
the
then,
litigation attorney.
let me stop you. Then I'm putting you in the order in which I receive your file, so just give me a moment.
Okay.
You'll be up. Nathan Cruz. Good morning. Where is Mr. Cruz?
I think he's in custody. I'm just here for Stephen Gilmore. He's in trial across the hall, so he asked me if I could just get this case recalled. The trial's been starting at 1:30 every day, but this morning it started at 9, so he was a little taken off. guard.
Okay.
So if it could just be recalled for next week.
All right, this is going to be recalled for March 7th. It's Nathan Cruz. He's in custody. All right, thank you. Good seeing you. Okay. Okay, awesome. Thank you. I didn't want to deny her her honeymoon. Okay, thank you. Sarah Gutierrez. All right, where are we on the evaluation? Have you completed your evaluation?
Yes, Your Honor.
Right. And when was that completed? On January 17th?
Yes, Your Honor.
All right, counsel, do you have the report from the doctor?
Yes, Your Honor. We conducted a hearing as well with Judge Carruthers. She was found competent.
Okay,
So we are moving forward. However, I did discuss with Mr. Escobar, the attorney for the state earlier today. Because there are still some present mental health concerns with Ms. Gutierrez, although she is competent. He and I are trying to determine the best outcome on this case in terms of resolution. He's wanting to reach out to his complainant in this case, as well as the complainant in her county court case, to see if we can come to some sort of resolution on these matters. We're requesting a plea deadline if possible in the third case.
all right. We're gonna do, your plea deadline date is gonna be March 7th. On Sarah Gutierrez, it's gonna be March 7th for a plea deadline date. Just have a seat. They'll call you for her to come up and sign the reset form.
Yes, Judge. Thank you very much.
You're welcome.
Thank you.
That's fine, Judge.
Who do you have?
That motion, that little B
Oh.
page.
Well, first we have
Oh,
Joseph Shubiak.
They're reviewing that file on Mr. Shubiak, so I don't
Okay.
have anything on that yet.
All right.
That's also mine.
All right.
I'd like to ask you a question off the record somewhere if I could.
All right. If you want to come around this way. Everyone, just give me 2 minutes.
Okay.
So before you leave, make sure you get that. How are we on discovery? All right, could I have a 30-day reset, please?
It's the permit that is going to expire, not the visa.
Right,
Okay.
and for that reason, I need you to talk to an immigration attorney and the court's gonna give you.
All right, we're gonna be back on March 28th. Again, before you leave, speak with them to see if Mac can have an immigration attorney appointed for him. If not, it will be Teresa Coes Davila.
Great, thank you, Your Honor.
All right, thank you. Do you have any questions?
Not at this time, thank you.
All right, you're excused.
Thank you.
Mayfield. Yes, she did. Here you go. Could I see the parties on Tamar McIntyre?
Do you want me to look call them back and ask if they can have one?
Yes, if you can call them,
Sure.
and if they can't, then Teresa Coes Davila. All right, today is the plea deadline date. So is the plea being accepted?
Rejected, Your Honor.
All right, so we'll need a jury trial date. I'm going to recall this. We're going to recall this for March 11th. And at that time, you will be given your jury trial date.
Okay. That'll work, Your Honor.
All right, so if you all can make sure you confer off docket to see what's a good date that works for everybody's schedule. I don't do special settings in this court, but I will take in consideration the fact that it's a date that you all have decided on.
That'd be great. We will confirm.
All right. All right, if there's nothing else, then you all excuse.
Thank you, Judge. Take care.
Thank you. And that's on McIntyre. You're welcome. Carball Mayfield. Who are the parties on Carball Mayfield? Move with the purpose.
I know no other way to move, Judge.
Okay. All right. Court is calling 2018 CR 11671, State of Texas versus Carball Mayfield. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Ted Wood for Mr. Mayfield.
Are you Mr. Mayfield? Are you Mr. Mayfield?
Yes.
Going to show you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Carball Carey Mayfield who was placed on deferred adjudication in 2018 CR 11671 for the offense of possession of a controlled substance, penalty group 2, 4 grams to 400 grams on April 29th, 2019 for a term of 4 years? Is that you?
Yes, ma'am.
State.
Yes, Your Honor. Violated condition number 2 on or about the 27th day of April 2022. The Bear County, Texas, the defendant Carball Carey Mayfield, the defendant there failed to submit to drug testing as directed by the supervision officer in violation of condition number 2.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the remaining violation.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor.
And what are you all requesting?
To deny the motion, continue the individual on his deferred, refer to felony drug court with a 2-year extension on his deferred. And judge, if he's not accepted in the felony drug court, it's an agreement that he will be sent to safety with an extension of 2 years.
All right, is that the agreement?
Yes, it is, Judge.
Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, you know yourself better than I do, better than your attorney does, and better than the state or probation does. If you want to be continued on probation, I will continue you. Otherwise, if you wish, I will revoke you and sentence you to 4 years. Which do you prefer?
No. He declines the offer for TDC, Judge, but thanks you very much for offering it.
Okay,
ma'am. I'm sorry.
no problem. All right, the court is finding violation of condition number 2 true. The court will deny the motion, alter and amend conditions for an extension of 2 years, a referral to felony drug court. Do we need an updated TAP probation? TAP in custody. And if not accepted in felony drug court, then safe P. All right, we're off the record. Mr. Mayfield, you got to make a decision in your life. And your decision is, do you want to go to prison?
No, ma'am, I do not.
All right, then you need to start acting as though you don't want to go to prison by following through on your conditions. You understand?
Yes, ma'am.
The agreement that the state and the defense came up with, I don't have to follow that because they don't have a contract with you. You have a contract with the court. So if there's an issue, if you're struggling, let the court know and we'll see what we can do to help you. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Who's here on Hillary Stillman?
Thank you, Judge. Might be excused, Judge?
Yes, thank you.
Judge.
And I'm sure you'll talk to felony drug court.
I'm supposed to be there half hour ago.
Okay. I'm not sure. I'll check and see. Yes, you did. No, Solace.
Oh, okay.
That's okay. Okay, just give me a moment. Court is calling 2022 CR 9437, State of Texas versus Hillary Matthew Stillman. Can I have parties announced for the record for the state?
Your head, Your Honor.
Defense,
Todd Lessert for Mr. Steelman.
are you Mr. Stillman?
Yes, ma'am.
Showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Hillary Matthew Stillman who was placed on community supervision for the offense of possession of a controlled substance penalty group 1, 4 grams to 200 grams on October 25th, 2022 for a term of 5 years? Is that you?
Yes, ma'am.
All right. And state, it's the court's understanding that there is only one violation in the motion? I see that that violation is a long violation to read. Defense, did you read the entire violation of condition number 44 to your client?
We did, Your Honor. We went over that, and we're going to be pleading true with an explanation.
All right. Any objection to the state just naming the condition as violation of condition number 4 as opposed to reading out the entire paragraph?
None, Your Honor.
All right, state,
Violated condition number 44, Your Honor.
how do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of condition number 44, the court could find it true, grant the motion, and sentence you up to 5 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 44?
Yes, ma'am.
Court will find violation of condition number 44 true. Is there a proposed agreement?
No, there's not.
All right. State, what are you requesting? All
Revocation.
right, defense?
Your Honor, and we understand the state's position on revocation. Mr. Steelman already has a plan in place should the court revoke his community supervision for him to get back on his feet once he's released from prison. He was hoping for a more constructive rehabilitation environment with the safe P. That was his mental health and physical health were not addressed properly. And he's currently being medicated for his mental illnesses. But we would ask the court to please impose the shortest sentence as possible for the court for revocation of this appropriate.
All right, Mr. Stillman, the court gives people chances in this court. If you have a drug or alcohol problem, if you have a mental health issue, the court gives that and tries to give that, but also protect the community. It shows in violation of number 44 that I recommended you for treatment and 2 times you refused to sign that. The court, as previously stated, is finding violation of condition number 44 true. Court will sentence you to 5 years in the prison, give you credit for any time served. There's a $1,200 fine, time and money will run concurrent. Did you pay the $57 to Bear County for drug testing?
I have not been yet. I've
All
not
right.
been out yet.
So there's to be $57 restitution to the Bear County Crime Lab. If you would like, I could recommend the therapeutic community for you at the prison. I have no control over them placing you in that program. It does not increase the length of time that you're in the program. Do you wish to be considered for therapeutic community?
Please.
All right. And I'll request the therapeutic community. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right. This was not a plea bargain agreement. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Do you understand?
Yes.
All right. Good luck to you. Okay.
Thank you.
You're welcome. Julian Martinez. Okay. All right. We'll recall it.
And provide verification of sober support meetings daily for 90 days, violation of condition number 23.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the remaining violated condition.
Any objection?
No objection, John.
Did you understand by pleading true to violation of condition number 23, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 23?
Yes.
Court will find violation of condition number 23 true. Is there a proposed agreement?
There's no,
All right, state, what are you requesting?
we're requesting that he be continued on this deferred and attend safety and remain in jail until that is available.
All right, what are you requesting?
Your Honor, we're just asking him to be put back in lifetime recovery. That's what my client would ask him. Finish that program. He does have other opportunities for him.
All right, Mr. Crispin, you have a choice. One, you can be continued, you're going to safety, or either I'll sentence you to 4 years in prison. Which do you prefer?
I guess they being.
All right, the court will deny the motion, alter and amend conditions. I'm so sorry. Before I do that, probation. Is this your recommendation for safety? All right, the court will deny the motion, alter and amend conditions to include safety. He's to remain in custody until transfer. All right, good luck to you.
Thank you, Judge.
You're welcome. Thank you. Always good seeing you.
See you.
Anthony Alves. Did you sign this? That's okay. Good morning. Yeah, thank you. Oops, sorry. And I think this is, oh yeah, this is county court. All right, court is calling 2024 CR 0733, State of Texas versus Anthony Alves. Could I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Lindsay Shaw from Mr. Alves. I'm appearing for Mr. Funk.
All right, are you Mr. Alves?
Yes, ma'am.
Do you have any objection to this attorney standing in for Mr. Bach?
Absolutely not.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, ma'am.
And counsel, I know that you have been representing Mr. Alves for less than 10 days. Are you waiving time?
Yes, Your Honor.
You have any objections to them waiving time?
No, ma'am.
The court will find that the state is in compliance with discovery, showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, I did, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, ma'am.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I did, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Alves, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea? Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, I did, ma'am.
According to the plea, the state is requesting that your punishment be assessed at 210 days under 1244. There are no applications. They're taking in consideration County Court Cause number 7200011. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor. However, we are asking the court to consider, as of today, our client has 123 days in the Bexar County Jail. He is a trustee and he's been working double time shifts, so back-to-back shifts daily. We're asking the court to take that into consideration and give him a credit for time served, judgment satisfied.
All right, but the plea is for 210 days. Is that correct?
Yes, Your
All right, state, is that the plea?
It is.
Showing you the waiver of appeal paragraph. Did you review that with your attorney?
Yes,
Did
I-
you understand it?
Yes, I did, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Honor. Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, ma'am.
State any evidence.
Yes, Your Honor. State exhibit along with all this attached.
All right. You may continue to confer.
Thank you.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I did, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right. Court will sentence you to 210 days in the Bexar County Jail under 1244, give you credit for any time served, and based upon counsel's representation that you're a trustee, the court will give you judgment satisfied. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, I did, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. You're gonna have to make better choices. Otherwise, you're gonna find yourself living in somebody's jail. You understand?
Yes, ma'am.
If you have a drug or alcohol problem, there are plenty of places where you can have free help. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Thank you. Alfredo Lugo.
Yes, Your Honor.
Yes. All right, what's happening with this case?
Your Honor, it's our first sitting. We've been given an offer and my client just needs a little time to think it over, and if we can just have 30 days.
All right, how old are you, sir?
58.
All right, on Alfredo Lugo, can I have a 2-week reset for a plea deadline date, please? All right, we're going to come back on March 7th. That will be your plea deadline date. At that time, you'll need to let the court know whether or not you're accepting the state's offer. Do you understand?
Yes, ma'am.
All right, once you sign a reset form, you can be excused. Just have a seat and they'll get the reset form to you.
Thank you, Judge.
You're welcome.
Oh, wait, we don't want the probation sheet.
All right, and Mr. Hernandez? Is he out, Hernandez? Okay. Morning. Hello, who are you here for?
John Lyles, Judge.
All right. Did you ask for them to pull the file?
I did, Judge. I asked him. That's all we needed to announce.
All right, I don't have the
Little
file.
Wellman.
Who do you need?
John Lyles. Alias.
Oh, thank you. John Lyles. All right, where are we on the case as far as discovery?
Discovery, I believe, is complete, Judge. We never, both sides attempted to get a video that is unavailable according to the facility, the store.
All right, so has an offer been tendered?
It has, Judge.
This jury trial to last.
One moment, Judge, sorry.
It's possession less than a gram case. Yeah. All right. So can we recall this back for March 5th?
Yes.
All right, we'll be back on March 5th for a jury trial. All right.
Judge, is there any chance we could do the week after that? I've got, on the 7th, I have a matter in Houston.
Oh, we'll see where we are.
That'll.
All right. So Lyles can go back.
Thank you.
You're welcome.
We need to sign it.
Matthew Hughes.
Warrant.
Oh. All right, your client has a warrant.
Yeah, I just heard about that. So I was thinking, can we, is it possible to recall him tomorrow so I can kind of figure out what the warrant situation is?
All right.
Touch base with him.
Deputy Laura, can we recall him for tomorrow? All right, but you need to be here at 9 a.m. If you're not here at 9, he's going to get sent back.
No worries.
All right.
Thank you.
You're welcome. All right, Matthew Hughes will be recalled for tomorrow at 9. Thank you.
Judge, do you happen to know the extension for county IT?
I'm sorry, what?
County IT for the courtroom computer? Or the
Deputy
extensions?
Laura knows it.
County IT. Thank you.
David Oliver.
Here.
O'Bara.
Yes.
Who's your attorney?
Mark LaHood, Judge, I'm here for Mark.
Okay,
He's been accepted to PTD, Judge.
all right. If you'll come forward, sir. Can I have a 1-month reset on David O'Bara? All right, we'll come back on March 28th. If your case has been dismissed, then of course you won't need to be here. Once you sign the reset form, you're excused.
Thank you, Your Honor.
All right, just have a seat. They'll get with you.
Thank you, Your Honor.
You're welcome.
You're welcome.
Who's here on Adrian Harper? Do you need a break? Oh, just have a seat. We're going to get with you in 1 second.
Say March 28th.
Yes. Okay. Yes. Yes. Well, actually, you don't need to do that. Mr. Chrisman? Come down, please. All right, Mr. Chrisman, I want you to hear me. Everyone, please whisper. I want you to hear me and I want you to hear me clearly. I want you to internalize what I'm saying. All right. So you are going to SafeP. If you do not sign the paperwork for SafeP, what's going to end up happening? Internalize what I'm saying. What's going to end up happening is a motion to revoke will be filed. That's it. That's what's happening in your case. You are going to SafeP. You're going to receive statement at SafeP. You're going to be at the Bexar County Jail till you're accepted into SafeP. That's what's happening here. Nothing else is happening. Now, there are consequences for actions. If you choose not to sign the paperwork, that's completely up to you. And then I'm going to have to take an action based upon that. And the action based upon that is probation is going to follow the state is in compliance with discovery. Mr. Shubiak, I'm showing you what's entitled application for deferred adjudication. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Shubiak, I'm showing you what's entitled court admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand your charge of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Correct. Yes, Your Honor.
All right. Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Okay. Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent, was legally sane at the time of the offense?
Yes.
Mr. Shubiak, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $500 fine. State recommends deferred adjudication in the DOEP course. Did you understand those, that to be the plea?
Yes, Your Honor.
Defense?
Yes, ma'am.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea. The state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation and 100 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence?
Your Honor, for State's Exhibit 1 in the attachments.
No objection.
All right, state you may continue to confirm.
Thank you.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Yeah, there's truly something wrong with the computer. All right, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
No, Your Honor, we just asked that the court follow the plea agreement.
Okay. And have I been pronouncing your last name correct?
Yes, ma'am.
Okay.
Yes, Your Honor.
All right, so who is Nicole?
My sister, Your Honor.
All right, and how old is she?
She's 37,
All right, and how old are you?
27.
All right, and who is Christian Bernal?
My brother-in-law.
Okay, is that her husband?
Soon to be, Your Honor. They're both on felony drug court as well. I don't know if that helps. Is that bad?
Well, I mean, it helps to see what's going on.
I mean, like, so my, like, I'm sorry, I'm nervous. No,
Don't be nervous.
yeah, no, those are my references, but I mean, y'all have like close ties to them. So that's the best referral that I could give you. I spend a lot of my time with them since they're in recovery. I'm in recovery too.
Okay, we're not doing a good job on recovery.
I'm trying, Your Honor.
All right, so what type of treatment are you in?
Right now, I'm just working a 12-step program. I have 6 months of sobriety under my belt, and then I'm also a student in school.
Okay, what are you studying in school?
To become a nail tech. I'm supposed to graduate May 1st.
All right, let me see your nails.
I don't have any on right now. I need
Okay, see. There are certain professions where if people don't have their nails done and they say they're nail tech, I'm like, I don't know. Now, if it's that stylist can't find anybody who's up to their standards, but nails, not so much. So they should be looking great. Okay. So how often were you using meth?
It was a daily thing for about 5 years. Yes, ma'am. In 2018, I tried to do an inpatient rehab, 30 days, and I just wasn't ready. I went back out and I was like, I'm gonna use until I'm done. And then come August of last year, I was just tired of the lifestyle that I was living. I wasn't going anywhere, like with myself. So I reached out and got the help that I needed to get sober. I'm in sober living currently.
Okay. And how often are you seeing Nicole and Christian?
Well, I live with my brother-in-law in sober living, and then I see my sister like almost daily because she's over there like with him at the sober
Okay,
living.
that may not, oh, so they're at the sober living home?
They're also like in sobriety.
So what did felony drug court do to them when they had a relapse?
Oh no, they haven't. Well, like they had relapse or because they had MTRs. They've been successfully completing their drug court.
Okay.
So like they're like 40.
Oh, this is an older case. Okay.
Yes, ma'am.
Oh, this is from 2021. Okay. Because I was about to be very upset that they're not working their steps.
No, no, ma'am, they are, Your Honor.
Okay. All right. This is what the court will do. I'm going to sentence you to 3 years deferred adjudication. Of course, if you complete everything early, then I'll consider early termination. I'm going him to continue with the sober living. We'll do a TAP evaluation out of custody. And if TAP recommends inpatient treatment, we're going to start with outpatient treatment to see what your program is that you're actually on. How often are you doing NA or AA or sober support meetings?
Anywhere from 2 to 3 meetings per week.
All right. So I'm going to put you at a minimum of 2 sober meetings per week. And you know what you need to do in order to maintain your sobriety. So if you need more than that, that's not going to make me look differently at you. All right.
Understood, Your Honor.
There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There is to be 100 hours of community service restitution. And if you complete your certificate or cosmetology or whatever it is for nail techs, I'll deem that the community service restitution is satisfied.
Thank you.
And we'll do a field visit one time, and we'll do it every 90 days, just to make sure he's doing what he's supposed to be doing. Probation, is there anything else?
Did you say employment, Judge?
I forgot. Thank you. Proof of employment within 30 days. No employment as a home health care provider or with minors. All right. Is there anything else you need from the court to be successful?
No, Your Honor.
Okay. All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing, in this court, to be successful on probation, communication is key. If there is an issue and you feel as though that issue is not being addressed, you can always come back to the court. Do you understand?
Yes, Your Honor.
All right, good luck to you. Just remain in the. See if I have the file. All right, where are we on Delo?
The last time we were here, Judge, we had just received the Houston Forensic Science Center's report for the DNA reanalysis. We needed to get the raw data from HFSC. They provided that to us. We've had a chance to go through that. We need to get it to our expert to go through. There's been some correspondence back and forth between HFSC and myself regarding some discrepancies that we found and some trying to figure out the rationale for their interpretation and the methods that they were using. One of them being the heritage probability versus the LR, which is the ratio that they use in another calculation. And we're just trying to just figure out where they're coming from on that. Spoken with Ms. Zamora this morning. I think we're at the point where we can try to get this thing scheduled for the 64.4 hearing finally. But we needed to go through a couple logistics with you just to try to make sure that we've got time to get this to our expert, let him do his analysis, get a report. Obviously, I'm sure the state's going to want to see that report, give them a chance to prepare that, get that to the state, give them time to analyze it. Bet more my client here and get it done.
Okay, what we're going to do then is I'll reset it for another 45 days. If y'all have everything before then, of course, we will urgently put it on the docket.
Okay.
All right, could I have yes?
We figure it's probably going to be an afternoon, probably a half day to get this done, probably 3 or 4 hours.
All right. Could I have a 45-day reset, and we'll set this in the afternoon at 1:30.
Judge, just one more thing. We anticipate the forensic science, somebody from their facility will want to testify. They're in Houston. I don't think Mr. McLean or I have an objection to them appearing by Zoom if the court is okay with that.
All right. Are you all right with them appearing by Zoom?
Absolutely. We discussed that this morning. I forgot to put that in there as well.
Okay.
Yes, that is fine with us. I think it's prudent.
All right. What date?
Roberto Ambrosino?
And are you Ralph Compost Jr.?
Yes, Your Honor.
Can I have a probation stamp, please? Going to show you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Ralph Campos Jr. who was placed on community supervision in 2020 CR 3586 for the offense of unlawful possession of a firearm by a felon on May 18, 2021 for a term of 5 years? Is that you? All right, state.
Violated condition number 2 on or about the 25th day of August 2023 in Bear County, Texas. The defendant Ralph Campos Jr. did then and there consume alcoholic beverages in violation of condition number 2.
How do you plead to that? True or not true?
And Your Honor, we'll waive the remaining violated conditions.
Any objection?
No objection.
Did you understand by pleading true to violation of condition number 2, court could find it true, grant the motion, sentence you up to 5 years in the prison and up to $1,000 fine?
Yes, sir.
Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor.
And what would that be?
And it is to deny the motion to revoke and continue the individualized probation with the addition to the levels of marijuana in his system to drop from this day forward into the allowable levels that are under the program that his doctor's prescription allows or the probation allows.
Okay. Is that the agreement?
It is, Your Honor.
Are you asking the court to follow that agreement?
Yes, sir.
All right, the court will alter the main conditions. The court is going to deny the motion, include 30 sober meetings in 30 days. You're not allowed to drink alcohol at all while you're on probation.
Yes, sir.
And he is to follow the medical recommendations of your physician as it relates to the marijuana use. Is there anything else from either side?
No, Your Honor. Can you recall the part?
Oh, just one moment before we get that. So there is a motion filed for early termination for you. That will be denied.
No, sir.
And the only reason why he has the warrant is because of this case? All right, the court will recall the warrant in 2020 CR 3586. All right, we can go off the record. You're gonna have to do better, you understand?
Sure.
For blood discovery, but we're just gonna put this on the 7th with your other clients since he's already gonna be here, and we'll see if they have a blood discovery.
Okay, Judge.
All right, so see you back also on March 7th.
Thank you. Thank you.
Pages. Esperanza Vasquez. All right, Deputy Laura, could you announce Vasquez in the hallway, please? Could I have a prosecutor? Court is calling 2024 CR 0285, State of Texas versus Esperanza Vasquez for the state.
Hank Wilkins for the state, Your Honor.
All right, this hearing was actually scheduled yesterday. The defendant was a no-show, and I asked that it be recalled today. The hearing was scheduled at 9 a.m. It is 11:44 a.m. and the defendant has not appeared. State?
Your Honor, we're asking for a bond forfeiture.
And Deputy Laura, was an announcement made?
Yes, Your Honor, there's someone under that name in the hallway.
All right, the court is going to issue a judge's warrant, remand her without bond, and she makes an appearance, the court will reconsider.
Thank you, Judge.
You're welcome. Sergio Martinez. It was Esperanza Vasquez on the recall last page. Christopher Acosta. Yes, I do. That's next. Court is calling 2024 CR 1657, State of Texas versus Christopher Acosta. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Megan Enriquez, present for John Hewens for Christopher Acosta.
And I'm assuming he's only pleading to one case?
That's correct.
Right. Are you Christopher Acosta?
Yes, ma'am.
Counsel, you received all the discovery. Did you review it with your client?
We did, Your Honor, and we have reviewed it.
All right, court will find that the state is in compliance with discovery. Mr. Acosta, do you have any objection to this attorney standing in for Mr. Kuntz?
No, ma'am.
Going to show you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it? Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? You're proceeding on one of the enhancements, is that correct?
Yes, Your Honor. Proceeding on the second enhancement.
All right. I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with driving while intoxicated third or more? Normally, that's a third-degree felony. However, the enhancement allegation is proven to be true, then your range of punishment will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Costa, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea, you are to agree that you've been previously convicted of one or more felonies for enhancement. Punishments be assessed at a cap of 10 years in the prison. There's a $1,500 fine. State opposes your application. They're taking in consideration 2023 CR 4342, and there's to be restitution to SAPD for blood and drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, sir.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And to the enhancement in paragraph 2 of the indictment, how do you plead? True or not true?
Truth.
State any evidence.
Your Honor, I offer State's Exhibit 1 in the attachments.
No objection.
All right, you can continue to confer. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, if we can go off the record for a moment. All right. So, state and defense. The court has in the steps, the judgments from paragraph 1, not from paragraph 2.
It should be behind that, Judge.
No. The other one is 4-8 unless in the indictment, it's incorrect. So I don't have 2014 3050. Yes.
Okay, they have a. Let me check on that, Judge.
Okay.
That's what they. 3050. 3050.
But there is the one that ends in W in there.
That's probably what we'll do, Judge.
All right, so then the state, are you proceeding on paragraph 1 of the enhancement instead of paragraph 2?
Yes, Your Honor.
All right, and defense, do you have any objection to that?
No, as long as
Correct.
the other one is being waived and
Yes. So how do you plead to paragraph 1 of the enhancement, true or not true?
True.
All right. Very good. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea of true and based upon state's exhibits 1 and attachments. Is it 6 weeks for? All right, so I'm gonna get a setting for you. We'll come back in 6 to 8 weeks. And at that time, I'll make a decision on your application based upon the PSI report, the top evaluation, and any other evidence that's submitted.
Okay.
Your Honor, I don't know what the timing is, but he has a doctor's appointment on April 10th. Can it be after that date of April 10th?
Sure. All right, we can put it for April 11th. Yes.
Thank you, Your Honor.
Before you leave, you'll need to sign the reset form and speak with probation.
Yes, ma'am.
Okay.
Thank you, Judge.
All right, thank you.
Thank you. Have a good one.
You too. That was Christopher Acosta. Yes, and it's for a sentencing. Yes. All right, just 1 second. I'll take that up in a moment. And we did not see him in the courtroom. Okay. All right. Adrian Harper. All right. Court is calling 2024 CR 1108, State of Texas versus Adrian Harper. Could I have parties announced for the record for the state?
Hank Wilkins for the state.
Defense?
He's for the defense.
And are you Adrian Harper?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
We have your.
Court will find that the state is in compliance with discovery. Is there an application in this case?
Yes, sir.
All right, I don't have an application. Oh, I'm sorry, I do. Papers are getting stuck together.
I apologize.
No, it's my fault. Mr. Harper, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Harper, I'm showing you what's entitled court admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of possession of marijuana, 4 ounces to 5 pounds? That is a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
That's correct, ma'am.
Did you understand? I'm sorry, just one moment. I'm noticing something on the docket. Sorry about that. Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he was.
Mr. Harper, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you understand if the court grants your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, ma'am.
Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, there's a $500 fine and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, ma'am.
State, is that the plea?
Yes, ma'am.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am. I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
Amen.
Outside the agreement, the state is recommending deferred adjudication for a term of 4 years, a TAP evaluation, and 120 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State, any evidence?
Your Honor, I offer State's Exhibit 1 in the attachments.
Any objection?
Objection, Your Honor.
You may continue to confer. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
I want to clarify something. Is my client being, I believe the indictment reflected a repeater allegation? Is that correct?
Yes, and the state is not proceeding on the repeater
Okay,
allegation.
that's what I wanted to clear.
Yes.
And what was your question?
Are you ready to proceed with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
I have reviewed the lab report and the amount of marijuana in possession. The lab report is like 14 grams more than 4 ounces. So it's really, I don't want to minimize it, but I would like the court to understand that we're not looking at a very large amount. We're not looking at anything near larger end of the scale. We're much closer to the smaller one.
All right. Are you employed?
Yes, ma'am.
What do you do?
I'm a server at Blue Prime Steakhouse.
I'm sorry, where?
Blue Prime Steakhouse, ma'am.
Blue Prime Steakhouse?
Yes, ma'am.
And I'm assuming the best thing in the order is the steak? Okay. All right, do you have any children?
Yes, ma'am.
Are they staying with you?
No, ma'am. They're with the mother of my children. We have a split custody.
All right, if you're drug tested today, what are the results going to be?
Marijuana for sure.
Anything else?
No.
All right, this is what the court is going to do. Court is going to sentence you to 3 years deferred adjudication. There's to be proof of employment within 30 days. No employment as a home health care provider with minors. Regular reporting by Zoom or in person. There is to be 120 hours of community service restitution. How far did you go in school?
I started my associates, but I dropped out when my girlfriend got pregnant.
All right, 120 hours community service restitution. That will be deemed satisfied if you have a degree or if you obtain some sort of certificate from a trade school. You understand? Otherwise, you're going to have to do the 120 hours.
Yes, ma'am.
There is to be regular UAs, tests for levels. I'm going to want 30 sober meetings in 30 days. Field visits, 1 time per month for 3 months, and then at probation's discretion.
Yes, ma'am.
Probation, is there anything else? All right, is there anything else you need from the court to be successful?
No.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You have children. What are their ages?
2 and 3, ma'am.
All right. I'm sorry, but Sean, can you add parenting classes, please? You should not be smoking marijuana when you have children who are that age or at all, because children learn from their parents. Do you understand? So do better. Be somebody that your children will be proud to say, that's my father, instead of saying, that's my father. I know his vehicle smells like drugs. I'm sorry. You don't want that on your children. You understand? All right, thank you.
Yes, ma'am. Have a great day.
All right, you too.
Thank you, Judge.
All right, you can take your leave.
Okay.
All right, could I see the file on Devin Strike?
Judge, let me grab my client. She's sitting in the hallway.
All right, thank you. Oh, actually, I'm getting pinch. Daniel Ramirez. Oh, if you have the file there, if you don't, that's fine, because I don't think he's on the docket. So just make sure the dismissal gets in there. All right, so Ramirez, where are we on discovery and other things?
Judge, Mr. Ramirez has 2 cases pending in County Court 8. One of them is a DWI from 2022 that was never filed. It was just a pending filing.
Okay.
I emailed the prosecutors down in County Court 8 to file that case.
Okay.
So we would like to get some more time, because we're talking about maybe this might be something we can resolve all 3 of the cases at once, Judge.
All right. On Daniel Ramirez, he's on page 6. Can I have a 30-day reset, please? March 21st? All right, March 21st. Once you sign the reset form, you are excused.
Thank you, Your Honor.
All right, thank you. All right, thank you, you too. All right, and I think Johnny's client, Gabriel Almanza, that was reset, correct? Because he's in jury trial. All right, and that's reset for March 14th. The attorney's on vacation. And then yes. Yes. No, do it as a judge's warrant, remand without bond.
Yes, ma'am.
Thank you. Juan Ramos?
He's in custody and timing wise, they're not able to bring him up.
No. So what we'll do is we'll recall it for next week. Are you able to be here next week?
Yep. Okay.
Okay. Oh, sorry, not next week. It'll be the first week in March.
Like the fourth week.
Yes, the week of the 4th. And it's only because there's a special case that's set for the end of the month and it's a murder case.
Can we do the fourth?
Yes.
I have one other case in here that day.
Yes. All right. So Juan Ramos is going to be recalled for March 4th.
Thank you.
All right. Thank you. Thank you for your patience. Hey, I'm getting better at sending my emails. You would be proud. Yes.
For content and.
Oh, yeah.
especially for the top
Well, you know my emails that I used to send? It would be like, hello, we need this. And he said, your emails are not flowery enough. Well, that's what you meant. I was reading your mind.
With the name,
Yeah.
just.
All right, Renee Torres. All right, on that case, there's going to end up being a bond forfeiture, but we're going to do that at 1:15. Just put that on the record. Yes, because
Requested on Saturday.
okay, well, that explains it.
Yes. So that's what the attorney just let me know. That's what. So, court is requesting a response Saturday.
Torrance.
Yes. So he's in federal.
All right, so what we'll do is let's reset this for March 7th to see what's going on.
And Judge, just that, I mean, we are proceeding on our cases. I
Okay.
found out through my supervisor.
All right, okay, thank you. Well, we'll make sure that we find out what's happening with the federal case to see when we can get it. And for my Texas people, where exactly is Carnes?
About an hour, it's on the way to Corpus.
Thank you. All right, everyone, the court is going on break. I have the files that I have. No other files have been presented to me.
There can be a motion that Zach had, state had agreed to for Thomas Lozano.
All right, so here's my question.
Yes, Judge.
And you know, I take everybody at their word that's in here. But if y'all want to have is there ad litem for the child in this case?
Yes, is it Stacy January or? Oh, Elena Pearsall.
All right, so if y'all want to have Elena Pearsall Zoom in here, I would consider this motion. But it's not going to happen today.
Yeah.
The earliest it can happen is maybe Friday.
Do we need to request to get on docket for it since?
Yes, if you just have them put it on the docket, but if we do it on Friday, it's at 9 a.m. And if anybody is not here at exactly at 9, then it's not going to be happening because we're in a jury trial.
Okay, we'll check with Alana then.
All right.
Should we take that back or do you want to?
Oh, you can leave it here and they'll
Okay.
put it in the file.
Okay, thank you, Judge.
Oh, here it is. Yes. Yes.
Mr. Smith and Diane Smith. We have an agreement. Paperwork needs to be completed.
All right, that's gonna have to come back.
So I would ask that we come back Monday. I have a funeral to attend this evening and tomorrow's the funeral.
Okay, we won't be able to come back on Monday because we have a jury trial that's specially set. If you want to come back this afternoon and we can take it up at some point during the break, otherwise we can't do it. And it won't be able to get done until the first week in March.
We couldn't do it during the break.
Well, that's what I said. If you want to get all the paperwork together and if we have a break during the trial, then it can be done this afternoon. Otherwise, it's going to be the week of March 4th. Sure, if you all want to do it on Zoom, but he'll need to have everything signed.
That's fine.
All right, thank you.
I appreciate it.
Yes.
The courtroom was silent as a father stood before the judge, hoping for mercy. Instead, he received a sentence that would change the rest of his life. The defendant had already pleaded guilty to causing serious bodily injury to a child by omission, an offense carrying a punishment of up to 35 years in prison. He asked the court for leniency, admitting he knew prison was likely, but hoping the judge would consider a lower sentence. During testimony, he insisted he never realized how severe his daughter's condition had become. He claimed he believed the child's mother was handling her medical care and that he trusted everything was under control. But prosecutors began asking difficult questions. They pointed out that the little girl was 10 years old, yet weighed only 27 pounds when authorities found her. When asked whether that seemed normal, the father repeatedly answered that he didn't know. The questioning only became more intense. The judge asked when the child had last seen a doctor. The answer shocked the courtroom. According to the testimony, it had been years.